April 24 question. As I'm presenting the first question, I want to do April 2024 question 5. Because it is about incorporation. I had done some compiling of the questions to see which questions apply in what part of the course outline. So we also follow the course outline as we do the questions. If there are no questions, I would wish to begin with this question. It's question 5 of April 24 paper. And the good thing is that we have taken the refresher course, so this first question we'll just answer it. Megan and Wayne are recent graduates of the world-renowned Culinary School of Kenya, and having graduated with flying colors, they now wish to venture into the restaurant business. Armed with preliminary research, they visit your chambers for counsel on the type of company structure that would best suit their needs as they incorporate a venture by the name Kula Sasa. Megan and Wayne explained that they have invited several of their former classmates, numbering almost 60, to join them in Kula Sasa as minority shareholders, while they retain majority shareholding. It's also their wish that Kula Sasa remain in the hands of original subscribers for the foreseeable future. Advise them on the following aspects. 1. Whether they meet the threshold of incorporation as a private company and the conditions that need to be met for the company to be determined a private company pursuant to the Companies Act 2015. Now, in this case, you shall be asked Companies Act Cap 486. You're there? Any takers on the issues arising? Any takers? Members, I wish to indulge you.
Kindly project the question.
Ladies. We repeat the question. Megan and Wayne are recent graduates of the world-renowned Culinary School of Kenya, and having graduated with flying colors, they now wish to venture into the restaurant business. Before I proceed to read, Miss Sheila, who taught us commercial in first term, she talked about generally answering of questions for CLE. And one point she noted is, teach yourself how to separate facts that are just adjacent to the question and the facts that inform the point of contention. What is the examiner looking for? So ask yourself that, and then separate that from the facts that are just there to confuse you and add a lot of information that is not particularly relevant to you answering any of the questions in that question, that particular question. Because there are so many facts, but you find the specific sentences from which they have derived the questions, and then the rest of the sentences they are additional. So armed with preliminary research, they visit to chambers for counsel on the type of company structure that would best suit their needs as they incorporate a venture by the name Kula Sasa. Megan and Wayne explained that they have invited several of their former classmates, numbering almost 60, and I want to stress this part, 60, to join them in Kula Sasa as minority shareholders. I also want to stress that about minority shareholders, where they retain the majority shareholding. It is also their wish that Kula Sasa remains in the hands of the original subscribers for the foreseeable future. Advise them on the following aspects. We are there with the question, so that we see question A again. All members, we are there. Okay. So whether they meet the threshold of incorporation as a private company and the conditions that need to be met for the company to be deemed a private company pursuant to the Companies Act 2015. Let's do Members, please. I indulge you. Let's do a discussion on that. Yes. Please unmute.
Okay, you had mentioned something about private companies being limited to 50 shareholders, and in this case, they want to incorporate the company with more than 60. So, in that particular case, it rules out a private limited, or rather, private company. So, what they would have is a public limited company.
Okay, well done, Wilkista. Anyone with an additional? Please unmute if you have an additional answer.
Okay, maybe if I can add something to help Modibu. So something that we also noted there with the private companies, the issue of is it limited by shares or limited by guarantee. So that's something they also have to consider for them to be deemed by a private company. And let me see, there were two individuals. So maybe you can scroll up. I can see the question. Towards something. Okay, so.
As we check on the additional points, the question is also asking about the threshold. What's the threshold for you to register a private company? And for you to answer that question, what section of the Companies Act provides for that? See section 9 of the Companies Act. Someone who has the Companies Act with them, and they can read out this threshold. As Wilkista had noted, that there are more than 60 members, which is to say that they do not meet the threshold for a private company. And as Chadwick has also noted that they also meet, then the options could be a company limited by guarantee or a public company. So what is the threshold you have to meet for you to register a private company?
Let me read section 9 of the Companies Act. It says that for purpose of this act, a company's limit is a private company if its article restricts a member's right to transfer shares, limit the number of members to 50, and prohibit invitation to the public to subscribe to shares or debentures of the company, requires the consent of all members to add a new member. It is not a company limited by guarantee, and its certificate of incorporation says that it's a private company.
So which is to say, thank you, Chadwick, which is to say that that is the threshold you have to meet for you to register a private company limited by shares, which is to say, Chadwick, how many points are in that section 9? How many subsections? For us to see these 5 marks, why it was well deserved.
How many subsections?
In section 9, so that we see these 5 marks where they fall.
Okay, there are 3 subsections.
There are 3 subsections?
Yes.
Okay, which is to say that the 5 marks are derived from you saying that pursuant to the Companies Act. If you remember the section, good. Then you state the 3 subsections, then you get your 5 marks. We shall go to question B, then we shall see the marking scheme. Megan and Wayne further explained that their former instructing chef, one Mr. Goldberg, may be interested in sourcing for some investment funds from some of his friends in Denmark on condition that Kulasasa's registration as a private company is completed and business has picked up. All this, Mr. Goldberg will do in exchange for some shares in the company. Explain to Megan and Wayne the following. Can they make such an offer to Mr. Goldberg and his friends? Should the offer be found to be in contravention of the law, what actions can be taken to bring the offer into conformity with the law? Again, we read the question again. Megan and Reed further explained that the former instructing chef, one Mr. Goldberg, may be interested in sourcing for some investment funds from some of his friends in Denmark, on condition that Kulasasa's registration as private company is completed and business has picked up. All this Mr. Goldberg will do in exchange for some shares in the company. Explain to Megan and Wayne the following. Can they make such an offer to Mr. Goldberg and his friends? Let's start there. It's 2 marks, so someone can just try the question. Just try. Please unmute if you have a. Can they make such an offer? The answers are still around section 9 to 12 of the Companies Act about whether a private company can make an offer to the general public. You see, let's draw down back to what we define private companies and public companies are. For private companies, you have your group of one member, a one-man company, like the case of Salmon v. Salmon Company Limited, and then you have 50 members company. But for a private company, any rights, any interest in that company are limited to the persons who have subscribed to the memorandum of association. Period. Complete. Apushamalize story. But when you go to a public company, you might find a public company con 100 members, but then you can also offer to the general public to subscribe to either shares or debentures or charges or lend you money. Hizi zenye zinaitwa corporate bonds. Hizi zenye zinaitwa all those things. ESOP, SAFE, simple agreement for future equity, all those. For in a public limited company, you can do all those. The reason being, the rights and interest in that company are not only limited to the members who are the shareholders, sayo. No, you can offer to the general public. Inaweza kuwa the shareholders wako hapa, then you also offer to the general public to subscribe to your shares. Unaona? This is what that question is testing. So someone please go. What would be our answer in this particular question? So that now we see the marking scheme after we see question 2 of the part 2 of the question B. Someone to answer in light of that about making an offer to Mr. Goldberg and his friends, because we are also assuming that now Kulasasa is registered as a private company in the right manner, which means that it does not have 60 members. It has up to 50, a maximum of 50 members. Someone please try. Yes, please unmute.
Okay, I'll give it a try, because they're saying Mr. Goldberg was a former instructing chef, but they haven't stated whether he was a member of the company or not. And in reading section 9 of the Companies Act, they say that in private companies, there is a prohibition in inviting members of the public or subscribers to shares or debentures. In this case, I think making such an offer will not suffice or won't be in accordance to what is prescribed in the Companies Act, since it's a private company and Mr. Goldberg is not a member, so it would amount to inviting investors from outside.
Well done, Wilkista. Well done. We should proceed now to part 2. Should the offer be found in contravention of the law, what actions can be taken to bring the offer into conformity with the law? So, yes, Abigail. Yes, please go on.
Thank you for that explanation, Wilkista. However, I had a very different approach on that question because I was thinking on, okay, in as much as Section 9, it says that a private company normally prohibits invitation to the public when it comes to subscription of the shares. But now I'm inclined to the fact that we were also taught about the issues on allotment of shares and transfer of shares. And this can only be done where there is consent of the already registered members or the maybe to say shareholders or directors, as well as the written resolutions that have to be passed. So I was also thinking on that line. I don't know if anyone was also on that side.
Yes, you're on the right track, Abigail. So, a refresh on part one of the question.
Maybe. Can I add something?
Yes, yes, please go on.
So I think Abigail is talking about the preemptive rights, such that the first, and also if Mr. Goldberg is more of he wants to be a shareholder, so being that he also in exchange of the shares. So first, the members also they have to sell first to the members before Mr. Goldberg comes in, and maybe how to absorb to get to know if Mr. Goldberg wants to be a shareholder in the company and what are the procedure to be followed for him to be a shareholder.
Well done, Abigail and Chebik. So, part one of the question asked whether there is an illegality. And for us, we say there's an illegality because they cannot offer shares to the general public. Then, section B, part B of the question now comes to ask you, if now you found that there's an illegality, how can you bring this whole matter to be in conformity with the law? And that's the part of preemptive rights. So I don't know if it is appropriate for me to share screen here. Let me just do it. So I'm looking for one where we have done a waiver of rights preemption. So let's see what a waiver looks like. So this is what a waiver of rights preemption looks like. So usually he just come and say we'll be the shareholders of XYZ. Waiver of notice. No, not no. It's not that. I'm not looking for that particular waiver. I'm looking for waiver when transferring shares. Yes, let's adjust this and let it load. So this waiver of rights preemption is a sample one. So now these are how you waive rights. The rights of the members who are already in the company to add more money to that company. So it is noted that this particular shareholder agreed to waive his rights to his shareholding proportion on the occasion of the allotment of additional this amount of shares in the company. That's the waiver on allotment. Then, so these are not a waiver in the instance of an allotment. We shall also see what's the difference of an allotment and a transfer of shares. So let's look for a waiver in the instance of a transfer of shares. This is how it looks like. We've been either undersigned being shareholders of this company XYZ. waive our rights of preemption on the occasion of below transfer of shares. Now, why are we doing a waiver? We are doing a waiver because we are waiving our rights, because the Companies Act for private companies, it places a right of preemption. A preemption means priority on the current shareholders to subscribe to any issuing of shares or transfer of shares or whatever it is, pursuant to their shareholding proportion. So if I own 20% and this company is looking for 100,000 Kenya shillings and I own 20%, I have a right to tell the company that instead of looking for the, before you look for the funds elsewhere, ask me for that 20% of the 100,000 Kenya shillings. So that if I am unable to contribute the 20,000 shillings, which is the 20% of the money we are looking for, then I sign a waiver of preemption. So now the company is free and it is in conformity with the law to go and look for funds elsewhere apart from the current shareholders. So we can have us look at what the marking scheme says. So the first question was whether they meet the private company threshold. Section 9 we saw. Section 9 describes private companies. A company with articles restrict the right of members to transfer their shares, limits the number of members to 50, and prohibit any invitation to the public to subscribe for shares or debentures. So the answer is a bit detailed, and the 50-member limit under Section 9(1)(a)(2) excludes only present and past employees of the company who acquired their shares or so employed and continue to hold them. It does not exclude any other category of shareholder. However, the relationship with the company arose. However, the relationship or later converted as a public company under Section 10, which carries no membership ceiling, but subjects the company to materially greater disclosure and governance obligations than they may currently want. So we saw that when we were discussing, we had pointed out that the option is to register a public company. So these are the option of having a corporate shareholder. So for example, we go and see, we want to have all these people, they want to become members of this company. But a private company can't have more than 50 members. So what we can do is we go and tell a few of the members to pool as a group. They register a company on their own. Then if there are 60, about 11 members, they go and register another company. They become members of, so if we are registering XYZ, they become members of ABC Limited. Then we bring in ABC Limited as the 50th member in XYZ Limited, you see. So in that case, all these people will be members of XYZ Limited, but the 11 will be members pursuant to beneficial ownership, pursuant to them being beneficial ownership of ABC, which is a corporate shareholder in XYZ Limited. I hope the point is home. So the two options are there. The two options is you can restructure to have a single nominee or corporate vehicle. They contribute, they come, register their company, then they enter as the 50th member. So that is allowed. Then they offer to Mr. Goldberg and his Danish friends. Can they make such an offer? Section 9(1)(a)(3) requires a private company articles prohibit any invitation to the public to subscribe for its shares or debentures. The Act at Section 2 defines prospectus broadly. Any prospectus, notice, circular, advertisement, or invitation offering shares or debentures to the public for subscription or purchase, and it is only a public company that may lawfully make such an invitation. The courts have given the public an expansive meaning for this purpose. In Re South of England Natural Gas, even a document expressly marked for private circulation only and sent to no more than 3,000 existing shareholders of a related group of companies was nonetheless held to be constitute an offer to the public because it was capable of reaching persons beyond a closed defined group. By contrast, Nashville Lindy 1929, a document that passed through a short, personally connected chain from a managing director to a co-director to a client to the client's brother-in-law, was held to not to amount to the issue of a prospectus at all, because the transmission was generally a domestic concern of the individuals involved rather than a document circulated to reach an open-ended class of persons. So specifically, what is the term given to the act of a company, that is a public company now, issuing an offer to the general public to subscribe to shares or debentures? That term is called a prospectus. It is only a public company that can issue a prospectus because a prospectus is like a quotation. It's like you're telling the general public, this is what you get when you subscribe to the shares. For example, when KPC was doing earlier this year, they published one all over Twitter, all over social media, all over the internet. They published a prospectus that anyone could access. You go and see the shares they are offering, at what amount, what are the benefits are coming from these shares, what is the nature of remuneration for the shareholders and such, dividends and such. But for a private company, you cannot issue a prospectus. And then there is a thin line where you balance between a document that has been circulated from a manager to the co-director, then to a client. That is okay. That is not a prospectus because it is genuinely individuals who are here. Unajua pia, even if you've been prohibited from issuing a prospectus, that is an offer to the general public, you're still allowed to go and look for funds. You're still allowed to establish enterprises. So you're only allowed to establish the enterprises to the extent of it not amounting to a public offer. On the facts, Mr. Goldberg proposes to source investment funds from some of his friends in Denmark in exchange for shares in Kulasasa. This is not a case of an offer confined to existing members or employees of the company, which the law treats as a genuinely domestic concern, falling outside the meaning of an offer to the public. Rather, it is an open and not clearly bounded group. Some of his friends, we don't know them, you see, with no prior connection to Kulasasa itself, being invited to subscribe for shares through an intermediary. This pattern sits much closer to the facts of Re South of England Natural Gas than to Nashville Lindy. And I would advise that without more, such an offer is likely to be treated as an invitation to a section of the public. If Kulasasa has by then been registered as a private company, extending this offer would place it in contravention of its restriction of its own articles and are required to contain under Section 9(1)(a)(3). So how do you cure this invalidity? You see, how do you cure the invalidity? Should the offer be found to contravene the law, Meghan and Wayne have several avenues to open them up, to bring it into conformity. The most straightforward is to narrow the manner in which the investment is solicited, and so it is directed only at specifically named and identified individuals who have a genuine pre-existing connection to the company or its founders, rather than an open invitation transmitted through Mr. Goldberg to an undefined circle of friends properly conveyed in this way. The arrangement would fall back within the domestic concern exception recognized in Nashville Lindy. Alternatively, Meghan and Wayne could elect to convert Kulasasa into a public company under Section 69 to 76 of the Companies Act, which would remove the prohibition on public invitation altogether, though at the cost of the private, because when you convert, you seize one, you close one, you convert to another. held character they otherwise wish to preserve. This would require a special resolution of the members passed by not less than two-thirds majority, reservation of an amended name. I think it was Abigail who was talking about the special resolution. There's the reservation of an amended name, amendment of articles to permit public subscription, lodging of Form CR17 together with the special resolution, the amendment articles, the relevant balance sheet and the auditor statement and report, culminating in the issue of a new certificate of incorporation. A third more surgical option is to restructure the transaction itself so that it is not in substance an offer by the company to the public at all. For instance, now this is what we were talking about. For instance, by having Mr. Goldberg personally subscribe for the shares and separately, in his own capacity, arrange his own financing with his friends such that the company's own invitation is directed as Mr. Goldberg alone rather than at his wider circle. So in answering the second question, we have seen that you are trying to balance the soliciting for funds and whether or not the manner in which you have solicited for funds amount to a public invitation, you see. So we have answered the April 2026 question, 5 question. Any other question before we go to November 2023 question? Question 4, November 2023. A question, a remark before we proceed to November 2023, question 4 question. Yes, please.
Okay, just to ask, other than the section 9, is there any other provisions that provide for the preemptive rights, the Companies Act?
Yes, preemption. Someone to check. Someone to check for us. But definitely there is. We just need to locate the particular section. There's a section entirely on preemption, rights of preemption and such. So preemption rights. Pursuant to Section 3 of the Companies Act. So members, do we look at what preemption rights are? Very quickly, we have a slide here on preemptions. Or I can send the same in the group. It would be easy if I did that, Cindy. Yes, members. Please advise.
It's okay.
I send in the group or I present.
You can just send it in the group.
Okay. So it is pursuant to Section 338. Then for us here, in this discussion, let's look at it in a summarized manner. So what are preemption rights? We shall just look at the first few parts of the slide and what sections are applicable. What are preemption rights? Rights of first refusal in favor of an existing shareholder holders that allows them to preserve their percentage shareholding in a company by being given the opportunity to subscribe for a proportionate part of any new shares that are issued. So the company is looking for investment. They're issuing shares or they are transferring shares. Someone, maybe even a director of the company or a shareholder of the company, would like to offer their shares for investment in the company. So they are selling their shares so that the company may get liquidity. Where they usually found: companies articles of association, shareholders agreement between company shareholders, trust deeds or terms of issue of any convertibles, options, and warrants. We'll be focusing on preemption rights under Companies Act. Section 338, it requires the company proposing to allot equity securities must first offer them on the same or more favorable terms to each holder of ordinary shares, pro rata to his existing shareholders. Pro rata to say that you are offered to the your first priority right on any allotment of equity securities or any transfer of shares, even from another shareholder to a new person in that company. You have a priority to request for the shares to be transferred to you, to your extent of shareholding, to your percentage of shareholding, so that if we are offering, if it's 100 shares in a company, I hold 20 shares out of the 100, and someone who holds, let's say, 40 shares wants to sell 20 shares. So I tell them that I am entitled to 20% of the shares they are trying to transfer before they offer them to anyone else. And that's what now is called the right of first refusal. I have to first refuse to buy the shares for you to sell them to someone else who is not a shareholder currently in the company. What are equity securities? For purposes of statutory exemption right, equity securities include both ordinary shares or the right to subscribe for or convert securities into ordinary shares. So what are we talking about, the right to convert? I had shared something here. I had shared as year 12, and I hope the members will allow me to share it one more time. The official search. So I want to explain the second part of this. So the first one is for ordinary shares. So ordinary shares are equity securities. So then, which is these other type to convert securities into ordinary shares? Unaona? Aya, come here. This is what we mean. Encumbrances section. This is why an encumbrance section is so important. So for example, the people who have loaned this company this money, they can choose, instead of being repaid that money, they buy shares in the company. And that's what we're talking about here, the right to subscribe for or convert any securities into ordinary shares. So instead of you, maybe for example, repaying your creditors, you can give them shares in your company. What are ordinary shares? Means shares that are shares other than shares that, with respect to dividends and capital, confer a right to participate only up to specified amount in distribution. The statutory preemption regime does not apply to allotment of subscriber shares, section 336. Why does it not apply? Because subscriber shares, they mean that, for example, you have 100 shares in a company. When you subscribe to the memorandum on articles of association, that is now before the Companies Act 2015. Companies formed before 2015. It was possible, the example I gave you, that it was possible for you 3 people to only subscribe one share, so that it remains that there are 97 unallocated shares. Then, when you talk about subscriber shares, it means that the 3 people who had subscribed one share, they will now want to subscribe to the whole 100, for each of them to get 33%, a third of the company. So it is to mean that the allotment of such shares, subscriber shares, they are not governed by preemption regime, because you're not transferring outside. It is still within the corporation. Allotment of bonus shares. Allotment of bonus shares, this is where the company has made a lot of profit. They wish to convert that profit into shares. So the preemption again does not apply, because the profit has been made from my capital as a shareholder. So there's no way bonus shares that you issued nje. Bonus shares, actually, they cannot be issued that side. They must be issued within the current shareholding, because it's my capital. Ile pesa yenye mimi nilitoa ndio imelead tukafanya business. We have made profit such that tunaona profit, instead of distributing it as dividend, we transfer that profit and convert it to shares. So kama kampuni yetu ilikuwa na 100,000 nominal capital, we see we have bonus profits of about 5 million Kenya shillings. So we just add 5 million shillings to our nominal capital, so that our nominal capital becomes 5.1 million Kenya shillings. And now because I had subscribed to, we were 3 people, I had subscribed a third of 100,000 in ilikuwa before. I also be given a third of the new bonus shares that have been issued. The 5 million nominal capital, nipewe a third of the shares because it's my capital ready. It will lead to us making profit. Allotment of equity securities that are paid up wholly or partly otherwise than in cash. Section 342. So see section 359 for meaning of payment in cash. What do you mean payment in cash? Payment in cash inamaanisha umedeposit pesa kwa kampuni. That's it. But there are so many ways. There are so many registrable instruments other than money, other than cash, other than liquidity. Unaona? There are so many registrable instruments. So for example, one type of equity security, I told you about sweat and blood. So for example, tunataka kufungua technology company. So for example, I am the proprietor of a company named Billboard AI.tech. So my developers, my engineers, I can pay them in equity for their sweat and blood. Unaona? Hawaja contribute pesa, but they can become shareholders by virtue of them being developers of a website. So their labor that they have contributed is what we are talking about otherwise than in cash. Unaona? So I allot them shares, not because they have contributed money to their 100,000 nominal capital. No, it's because they have contributed their sweat and blood, their labor to the development of this company. So we will make profit from their sweat and blood, their labor, which is not cash, otherwise than in cash. That's what it means. Allotment or transfer of shares and an employee scheme. You see, this is another thing. An employee scheme ni ile yenye tulisema ESOP. Kumbuka kulikuwa na exemption kwa section 9 on offering of shares ama when the number of members exceed 50. If it is an employee scheme, huko kulikuwa na exception that a employee scheme unaweza kuwa na 50 members, then unaweza ongezea employee scheme on top of it. So useme other than the 50 members who are subscribing, kuna employees wa kampuni 51, 52, 53 members. Unaona? It's allowed because they are part of the employee stock option plan. It's called ESOP, ESOP, employee stock option plan. So when you're transferring shares under an employee scheme, now we go back to section 343. It is not the preemption regime does not apply because we are doing this to service a business obligation or a business commitment of the company. So in order for a company to run, we must transfer these shares. So they cannot be, the preemption regime cannot apply. So there is so much on preemption rights, but I wish we'll read that slide. Please go and read it. I hope we cannot continue past that so that we go back to the questions, and I hope the members will read on preemption rights. Please read those slides, some of those slides, so that I see November 2023 now. I look for the question. In the meantime, any other question? So, yes, if I proceed.
So these equity securities are like the loans that have been advanced to the company, or what have you?
Loans is one. What I've talked about, labor from employees, is another thing. Another type of an equity security would be, other than debentures, charges, and such, it would be a floating charge. Another equity security would be intellectual property rights. So for example, I have developed a platform, but for me to make money, I need certain IP rights. So there's somebody who owns IP rights, intellectual property rights to a certain system or a development or a way of doing work. And for me to do business, I need their permission. So they just come, I register some shares in their name, they allow me to use their IP. That's an equity security. It's a whole other thing. Kuna maneno na trademarks. Inaweza kuwa trademark imeholdiwa na mtu mwingine. They usually trade on that trademark. For a trademark ni, I go register a trademark, I say, it's only me who can make money using this. And if you make money without my permission, then I sue you in court. So the only way is to come to me, tell me that I want to use your trademark to do certain business and such. So it can also be an equity security in that instance. So it's a whole thing. It's a whole thing. It's a way of financing businesses that you have to expound it on a case by case basis. Any other inquiry from the members before we read question 4? So that, and I also want to inquire from the members, when do we take a break so that we can, and also we agree on when we are convening. We continue with the past papers now. I like it that now we are on track with the past papers. So the more we do the past paper questions, the more we see how businesses operate. The more we get familiar with the Companies Act, it becomes so friendly. Yes, I know the Companies Act is more than 1,000 sections, but I usually find reading the Companies Act even much what can I say? It's less bulky, even with those 1,000 shares, than reading, for example, the Evidence Act for me, because the more you relate to the practice, you relate with how the movement of operation of businesses, how businesses operates generally, then you are able to acquaint yourself with the Companies Act and now the regulations, the subsidiaries that are pursuant to it, and the other acts that are relating to businesses, Registration of Business Names Act, the Limited Liability Partnerships Act, and such. So let's proceed to question 4 if there are no other inquiries. Members, when do we take a break? At 12? And then we can then decide on when to proceed. If that's okay with the members, we take a break at 12 after we have tackled question 4. Okay, it is agreed. Jenga Limited is a private real estate company, limited the shares, which has adopted the model company MEMATS. The company's nominal capital is Kenya shillings 100,000, each share valued at 1,000 shillings. So it has 100 shares. Then each share is valued at 1,000 shillings, which makes its nominal share capital to be 100,000 Kenya shillings. It was incorporated in 2015 by the late Richard Kumo. Jenga's directors and shareholders are adult children of the late company founder. And until recently, they have been able to peacefully coexist with respect to the day-to-day running of the business. The director shareholders of the company are, so we have David Kumo, shareholder, 10 shares, Rose Kumo, director shareholder, 35 shares, and Simbia Kumo, director shareholder, 35 shares. So right now we have only 2 directors, we have only 1 shareholder. I hope the members can note that. Then these shareholders, they have subscribed to a total of how many shares? 80. So there is 20 shares yenye bado hatujajua ni nani as per, yani penye tumefika kwa the fax pattern, we only know who are the ultimate beneficiaries. And with aid of relevant provisions of law. The notice issued by David. The notice issued by David. This is a good one. This is a good one. This one is talking about directors, how you call a meeting to appoint directors and such. So we had not covered it in the refresher, but I hope the members can make a try. The map is later.
Brian,
Yes.
kindly mute Vic because there's a lot of noise from this end.
I don't know why.
Victor, kindly mute.
Kindly scroll up. Okay, scroll down, scroll down. Okay, proceed. Scroll down.
I've been muted this whole time. I've been talking and talking. Apologies. So it seems whatever I've been saying, I've talked about this already. Okay, the issues that I raised was one, whether David, even without considering whether he has the capacity or he meets the threshold of being appointed as a director. First, ask yourself: does he even have the capacity to call an annual general meeting, so that we know? Because we are asking that, first of all, he does not have a capacity to call an annual general meeting because he's only a shareholder with 10%. Secondly, he does not meet the threshold of being named a director of the company because he has recently been adjudged bankrupt. So there are a lot of issues arising. And we are critiquing David's notice as a company secretary. As company secretary, I would advise that the notice David has issued is defective on several independent grounds, any of which would suffice to invalidate the purported meeting. The first and most fundamental difficulty concerns the authority to convene the meeting at all. David holds 10 shares in Jenga Nchi and is a shareholder, but he is not and has never been a director of the company. That's what we have noted. General meetings of the company are ordinarily convened by its directors, acting collectively as the board. So David does not even have the capacity to call a meeting on his own volition. That's the first thing. Where a member wishes to compel a meeting to be held, the correct statutory route is to requisition one under the Act, which entitles members to holding the requisite proportion of voting rights to require the directors to call a general meeting. The member does not thereby acquire the power to call the meeting personally or unilaterally, still less to dictate its agenda in the way David has attempted here. David has bypassed this procedure entirely and has simply purported to summon the company shareholders on his own authority, which he does not have. He has no authority actually, because the reason he does not have any authority, you remember when we were looking at the beneficial ownership BOF1 form, there's a place it was asking you, does this director have the significant influence or control over the company? So that you answer in either he has a direct influence or indirect. And for David, it is of course indirect. The second difficulty concerns the length of the notice given. David has only given 7 days notice. This is another issue, because the notice should be more than 21 days. Of what is styles an annual general meeting, a private company is required to give not less than 21 days notice of a general meeting, unless its articles provide otherwise, or a shorter period is agreed to in writing by all the members entitled to attend, or unless, for example, what we are calling a shorter period, unless you have signed now. These are the waiver I was showing you. This waiver of notice of annual general meeting of shareholders, with the undersigned being all the shareholders of the company, hereby agree and consent that the annual general meeting of the shareholders of the company be held on date and time at a place designated hereunder, and do hereby waive all notice whatsoever of such meeting and any adjournment or adjournments thereof. We do further agree and consent to any and all lawful business may be transacted at such meeting or at any adjournment or adjournments thereof as may be deemed advisable by any shareholder present thereat. Any business transacted at such meeting or adjournment or adjournments thereof shall be valid and legal in the same force and effect as if such meeting or adjourned meeting were held after notice. So even David has not developed such a document, a waiver of notice, which is usually signed by the shareholders. So that's another issue. So let's go back to the marking scheme. A private company is required to give not less than 21 days notice of a general meeting unless its articles give a shorter period. So hii pate in writing, hii yenye tumeona, the waiver. Nothing on the facts suggests that Rose and Sylvia, the other two shareholders, have consented to in writing to the shortened notice period. So hiyo waiver tumeona hapo, David hata hakuifanya, unaona. On the contrary, the facts indicate that the notice has taken them by surprise. This 7-day notice is non-compliance with the statutory minimum. That, and particularly serious difficulty, concerns David's own eligibility to be elected in the first place. That's the other thing. David has recently been adjudged bankrupt. Section 152 of the Companies Act provides in clear terms that an undischarged bankrupt may not act as a director of the company without the leave of the court. There is nothing on the facts to suggest that David has sought or obtained such leave at the time he issues this notice. He is, in other words, purporting to engineer his own election to position the law currently the law currently disqualifies him from holding, which renders the entire exercise premature at best and unlawful at worst. No. So the other question is his eligibility. Does he even meet a threshold to become a director? No, per section 152 of the Companies Act. Finally, the substance of what David proposes compounds these procedural defects. He seeks not merely an election as a director, but simultaneously appointment as a sole signatory with authority to conclude the sale of the company land. A transaction he has himself been actively promoting through unauthorized billboards advertising a development on that very parcel. Well before he held any office in the company entitling him to committed to such dealings. He was not a director. This is plainly self-interested arrangement engineered by David in his own favor without any board deliberation, disclosure, or the involvement of his co-shareholders in a manner consistent with proper corporate governance. His reference to appointment under seal is also legally unnecessary. Companies are no longer required to execute documents under a common seal. This is another part. Anasema his appointment equal under seal. You know, under seal means something that is okay. We'll see it. A document being validly executed if signed by two authorized signatories or by a director in presence of an attesting witness. Taken together, the notice is invalid for want of proper convening authority, inadequate notice, proposed appointment of a person presently disqualified from holding office as a director. So this is the whole thing. Is the whole answer. This one sentence. So his authority. So we go back to the question so that we just digest the whole of it better. So the question had referred to this first part. So the first part is David is an adjudged bankrupt. So that means per section 152 of the Companies Act, he does not qualify to be elected as a director at all. The other thing, he has put up billboards, he's running business of the company, yet they are unauthorized by the company. So he's acting ultra vires to what the powers of a directors are. And not even the powers of a director, because he's not even a director. The powers of a member of a company. He's acting ultra vires in his relation to him being a member of the company. The other thing is that David cannot call an annual general meeting because he's not a director. The annual general meeting must be called by the board of directors. And how does the board of directors call an annual general meeting? So let me give you the context now. So for example, you register a company on today. Today is the day you have been given a certificate of incorporation, 9th of August 2026, which is to say you shall be returning your annual returns to the register of companies on every birthday, every anniversary of the company. So next year on 9th August 2027, we shall return our very first annual returns. Then the following year, the second annual returns. That way, you should return those every year. Higher. When is an annual general meeting held? Under the Companies Act, an annual general meeting must be held within not less than 14 days before the date of the anniversary. Not less than 14 days before. Not less than before, as in, so it should be around 27th of July. The annual general meeting for the company that has been registered today. Ndio sasa ikikuwa the date of annual general meeting inakuanga 27th of July, you must issue a notice for that annual general meeting 21 days before the date you hold that annual general meeting. So 21 days before 27th of July is 3rd of July. So what we do is you issue a notice 3rd of July, the board of directors collectively wanasign mahali ama wanaissue a waiver. Ebu acha nionyeshe waiver tena. Wanaissue a waiver. This is what a waiver is. Unaona? Wanaissue a waiver. So wana waive and wanasema that such meeting or adjourned meeting were held after the notice. It's just so this waiver is to waive the requirement for a notice. Let's see what a notice looks like. So this is a notice of a general meeting. A sample. Let me call this company XYZ again. Company number we delete. The agenda of the 2025 annual general meeting of the company pursuant to provisions of the Articles of Association in the Companies Act. And actually, I should come here and say provisions of Article what? So if it is here, you should come and say Article 17. So if it is Article 15, Article 15 of the Articles of Association, and what section and section, you should also say the section of the Companies Act. Section what? Kindly someone rush to the Companies Act, tell us what section requires companies to issue a notice of annual general meeting. Kindly. So as I take the members through what an AGM notice looks like. So this is an AGM notice. Someone to go and check which section we should put here, because you should mention the Articles of Association article and the section. It should be there. Then, dear members, notice is hereby given the 2025 annual general meeting of the shareholders of XYZ Limited will be held on --2026 10 a.m. to consider and without peace pass the annual return 2025. So kumbuka tumeongelea the annual return. Annual return tulisema ni the birthday, the anniversary of the company. So this meeting kama tumepeana notice tuseme date ya hii iko dated tulisema ni 3rd of July, si ndio? Acha hata tuifanye practically. 3rd of July 2026. Ndio kuja useme the agenda itakuwa opening and welcome, confirmation of quorum, presentation of the register of members and shareholding. And shareholding hiyo lazima uambie members shareholding yake iko wapi, iko aje. Yes, someone has raised their hand. Please unmute.
It's section 275A of the Companies Act.
Thank you.
That talks about annual general meeting.
Yes. So you should state in the notice what section of the Companies Act you are calling this, you are issuing this notice under. It has to be sanctioned by the board of directors, and for it to be sanctioned, it has to be sanctioned under the Companies Act, under the Articles of Association. Presentation of annual return 2025. So the annual return was already prepared. So we will present it. So we said the notice is dated that July, but the meeting will be held on. Kumbuka hapa tunajiuliza, the meeting will be held on. Tulisema 27th July, si ndio? Oh, 27th July, yes. July 2026 at 10 a.m. East African time. Si ndio? Haya. The annual return 2025 tulisema 2025. Yes, it's for 2025. Presentation of financial statements for the financial year. Remember, the anniversary of the company and the financial year, they are two different things, because this is an accounting date. This does not concern on the date the company was registered now. This is just an accounting date, a different accounting date. This is the financial year of the company. So the financial year of the company usually have an end month. So it can have 31st July, it can be 30th June, it can be this. No. Directors remuneration. If you are paying the directors, auditors, another agenda inafaa kuwa dividends, whether dividends will be paid. Then kuna auditors, kuna approval of annual return. Then una authorize the company secretary to file annual return 2025 with the business registration service and any other business. Then unaweka notes. This is very important. Unaweza iweka useme that this meeting was convened the waiver. Sasa the waiver, ile waiver tuliona huko, it's pursuant to section 281. Unaona? So the required statutory notice period for annual general meeting is 21 days. This meeting is convened on shorter notice pursuant to section 281. Even though our meeting is convened on proper notice, you just include it for safety. Wewe sema tu, if there's something about short notice and waiver, the members have also agreed to waive a notice, waive this particular notice that I'm issuing. It's well and good. Then all the directors, they sign, because a notice is issued by the board of directors. So in our case, yenye tulikuwa, so hii tumeona ni section 281. A waiver is done pursuant to section 281. Haya, tutoke hapo. turudi kwa swali yetu, kwa the question. David amecall a new general meeting. He proceeds. David is confident that the advertised project will change his fortunes for the better and proceeds to call a new general meeting. Haya, of the company akapeana within 7 days. So hizi defects zote ndo tumeenda tukaanalyze, then we answered the question. So as at that, I think the question is answered. I hope you're all there. If there is any question, please ask. If there is none, I wish to proceed question B so that we close at 12. David has been granted by the court to be appointed as a director of the company, and his siblings have agreed to transfer 5 shares each to David, and for the company to allot 10 shares to David, so each director shareholder will have 30 shares each. Proceed to draft a detailed memorandum to director spelling out the required documentation to effect the desired changes. This is a very interesting one. I want to take you, before we go to the marking scheme and before someone attempts to answer, I want to take you back to the question. This part, kuna hii part yenye niliambia you note very carefully. David Kumo shareholder 10 shares. Tulisema hii kampuni kuna shares ngapi? 100 shares, each of 1,000 shillings, so the nominal share capital is 100,000. So tuko na only 100 shares kwa hii kampuni. Haya, tuanze tena. David Kumo shareholder 10 shares. Rose Kumo director shareholder that 5 shares, and Cynthia Kumo director shareholder that 5 shares, which totals to 80. So the issued share capital in the company is 80 shares, which is to say that 20 shares in the company are unallotted, they are unallocated, they are unissued, they are just floating in the air. No, we do not know who is the beneficial owner. But again, for you to know a beneficial owner, you just look at percentage. So those shares, 20 shares, they are not held by anyone. David has been granted by the court to be appointed as a director. So tulisema, the exemption is that juu kwa judge bankrupt and a sick leave of the court to be appointed, sindio? So we assume amekuwa appointed. Haya. Siblings have agreed to transfer 5 shares, each to David. Unaona? So, Cynthia Kumo na Rose na who Kumo? Cynthia Kumo and we have Cynthia Kumo and Rose Kumo. They each have that 5 shares. So I want us to draw a table. In the marking scheme very fast so that ndio hata tutaweza kujibu hiyo swali mbio so that we close at 12. So before we draft the memorandum, let's draw a table here to try to visualize these things, ndio. So hapa ndaandika, I hope everyone is with me as I do this. Name of member. Hapa ndaandika description. Then I will add another column. Hapa ndaandika shares. Number of shares. It's called number of shares. Of ordinary shares. For this company, it's ordinary shares of Kenya shillings. Tuliona ni 1,000. 1,000 each. Then changes. Sasa the last column ni changes, si ndio? Haya, changes, si ndio? So tuko na Rose Kumo, tuko na Cynthia Kumo. I hope the members are with me. David Kumo, si ndio? We saw Rose Kumo is a director stroke shareholder. We saw that Cynthia Kumo is also a director stroke shareholder. And we saw that David Kumo is only a shareholder. Sorry. He's only a shareholder. So that's the position of the company now. The number of shares, alafu ndaka ni the number of shares that Rose Kumo saizi yako nao ni 35. The number of Cynthia Kumo is 35. The number of David is 10. So the total Niandike another row ya total. So the total yenye issued saizi, total issued ni 80. Sindio? We want to make changes in the following manner. Let's go back to the question so that we see the changes. So this is how you do it. Just tengeneza ka table. Ukipewa swali kama hii ya kujui shares, sijui allotments, sijui nini, just make a table. You will never go wrong if you make a table because it's just simple numbers. After you made the table, unaangalia to the numbers. Haya. Siblings have agreed to transfer 5 shares each to David for the company and the company to allot 10 shares to David. Sindo? So, hapa penye niliandika changes, nitatoa hiyo word, nitaandika transfer of shares. Alafu I will add another column. I will call it allotment of shares. Chani tengeneza hapa allotment. So they have agreed 5. So Rose Kumo 5 ordinary shares unazitanga 5 ordinary transferred to David Kumo. Haya. Then Cynthia Kumo unaandika the same thing because hivyo ndo tumeambiwa kwa facts. Bado tuko kwa facts. Bado hata tujaanza kujibu swali. Haya. Then David Kumo tunamwandikia hapa 10. Hata si 10 ni 5 ordinary shares. Sasa instead of transferred ni received from Rose Kumo. Then we have another 5 ordinary shares received from Cynthia. So let me just push this to the next page so that the whole table iko visible vizuri. I hope you can see my table. Okay, we are there now. We've said that we are allotting again. Let's go back to the question. We are allotting 10 shares to David. For the company to allot 10 shares to David. So 10 shares received in allotment. Received. Actually, hii column hakukuwa na haja ya kutengeneza. Let me show you what we do. We just add it here and we still call the column equal to bado ni changes. So that we remove this column. Transfer of shares and AIDA and allotment. Now this is what the first fact pattern looks like. This is the 5 marks unaulizwa. Hii ndio question B. Unaiona? So in total David ataenda kuwa na shares ngapi? Sama. Just from the table. Total ya David eventually itakuwa ngapi? So hapa kwa David tunafaa tumwandikie. So first of all total ya Cynthia Kumo itarudi 30 juu ilikuwa 35 asha transfer 5. Sasa tunafanya swali. Total ya Rose Kumo itakuwa 30 juu ilikuwa 35 ametransfer 5. So what's the total ya David? Someone kindly very fast. What's the new total after tumefanya the transfer of shares and the allotment? It's kindly someone very fast.
It's 30.
It's 30. 30 because he had 10 shares. He got 5 shares from Rose, got 5 shares from Cynthia, and then eventually he received 10 shares in allotment. No. So inakuwa 30. So it means the total size ni 90. Total issued shares in the company ni 90. Total unallocated ni 10 sasa. Then let's answer a question. Proceed to draft a memorandum to the director spelling out the requirement documentation to effect the desired changes. So for me, I would think this memorandum you've been told to draft is a legal opinion. I did not follow the format for legal opinion on answering. Apologies for that, but we can see what I came up with. So let's see the memorandum now. To the directors, Jenga Nchi Limited, from company secretary. Okay, it's not a legal opinion, by the way. You are the company secretary, and that's the reason why these facts didn't exist. So you're the company secretary. So it's an internal memo, actually. It's an internal memo. It's not a legal opinion, or this is not even a client that Yamako approach. It's not a new client, no. You're the company secretary, which is to say that it's just an internal memo. You're just advising your directors. This is internal company business. So reference, documentation required to give effect to David Kumo's appointment as director and associated share transfers and allotment. Following the court's grant of leave under section 152, permitting David to act as a director notwithstanding his undischarged bankruptcy and the family's agreements that Rose and Cynthia will each transfer 5 shares to David and further allot him 10 shares, bringing each of the 3 siblings to 30 shares apiece. I set out the below documentation that will be needed to give proper legal effect to these changes. First, we will need a certified copy of the order itself, true, granting David to leave to act as a director despite his bankruptcy. Should be retained permanently on the company's statutory files, since it is the instrument that lists the section 152(1) bar and is the foundation for everything that follows. On the strength of that order, the members should pass an ordinary resolution formally appointing David as a director at a properly convened and duly noticed general meeting, this time convened correctly by the board on statutory notice period. Once appointment, David particulars must be filled with the registrar on form CR6 and his residential address notified on form CR8, both within prescribed period prescribed by the act. So very fast, I want us to see what's from CR6 and from CR8. They are just 1 page each, so tunaweza angalia tu. Can just see very fast. So the forms, these are the forms I'm presenting. So these are the company registry forms from CR6, notice of appointment of directors and their particulars. So this is what it looks like. Forms for Kenyan companies from CR6, notice of appointment of directors and their particulars. It is pursuant to section 138 of the Companies Act. Your name of the company, it is, the name of the company was? See what's the name of the company we had. So the name of the company is Jenga Nchi Limited. Number of the company, you just enter it. To the register of companies, Dash Company Limited gives notice in accordance with section 138 of the Companies Act that the following persons were appointed as the director of the company. Unaweka director 1, their name. If they have a former name, maybe they change their name, the date of appointment, the postal address of the director, address for service, nationality of the director, passport number or identity card, occupation of the director, unaweza andika tu businessman, date of birth, telephone number, email address of director, details of other directorships held by the director. So kama yeye director kwa kampuni nyingine unaandika, has the director consented to be appointed as the director of the company? Unaandika yes, then unapeana an acceptance letter, then director 2 hivyo, director 3 there is hivyo. Then we see form CR8. So these are the 2 forms tuna fill for David to become a director. Hizi forms ziko kwa Companies Act regulations na ziko hapa kwa BRS. Kwa hiyo link ya registry nituma. So notice of hii tulikuwa tushaona. Tulikuwa tunaona when from CR8 notice of residential address of a director. Hii tuliona iko pursuant to section 138. Tuliona when we were seeing how to register a private limited company. So we go back to our working scheme. So we have seen from CR6 and from CR8. Turning to shareholder changes, the transfers from Rose and Cynthia require separate share transfer deeds, each duly executed by their respective transferor and by David as a transferee, witnessed and stamped in accordance with Form D for stamp duty purposes. Once executed and stamped, This should be lodged with the company together with, from being very important actually, in if eco-filled by the company accountants, together with the existing share certificates. Share certificates tutaangalia later, we see what are share certificates, so that the transfers can be registered. Separately, the allotment of 10 new shares to David requires its own board and company resolution authorizing the allotment together with the letter of allotment recording the company's acceptance of David application for those shares. In verifying this allotment, it is worth confirming that the company's total issued shares will not exceed its nominal capital, with 90 shares in issue. Following the allotment against a nominal capital of 100,000 shillings, divided into 100 shares of 1,000 shillings each, and the company remains comfortably within its authorized capital, and no increase in nominal capital is required. So increase of nominal capital is another whole thing. Once the transfer deeds and the allotment are processed, the register of members must be updated to reflect each of the 3 siblings holding 30 shares, and this should not be done. This should be done within the statutory window. The Act requires transfers to be registered and new share certificates issued within 2 months of the company's receipt of the relevant documents. New share certificates should be issued to each of the 3 shareholders, reflecting their updated 30 shares shareholding. Finally, the registrar of directors should be updated to reflect the appointment, and the company's next annual return should capture both the revised shareholding structure and the changing company's directors. So quickly, I want us, I hope the members have gotten it. So quickly, I want to take the members through what such an application as a company secretary would look like, even though you're not now required to draft the documents hapa kwa hii swali. Hapo muuliza tu memorandum, you advise the directors. But now, what does that particular, what do those particular documents look like? Let me see if I have one. Sijui kama niko nayo. So this is under all confidentiality. So this is what you usually do. I hope but the good thing is that no one is recording. So resolution signed by all the directors, then unaanza the first resolution, increase of issued share capital. Lazima ikuwe dated pia. Sinaona. It is resolved to recommend shareholders to consider. So this is an increase. So we are not doing increase in this one. We are only doing allotment and transfer. So kumekuwa na increase, tumeanza na increase, we increase. So we are not doing increase, we just go direct to what we are doing. Allotment. Resolved to allot a total of 10 shares. So for our case, let's just draft it. 10 ordinary shares of Kenya shillings 1,000 each as follows. So the name is David Kumo. David Kumo. We are allotting him only 10 shares as per the facts. So upper total itakuwa 10. Then we are transferring shares. We are transferring from Simbia and Rose. We are transferring to David. We are transferring both to David. Then the number of shares, 5 shares each of 1,000 shillings, 5 shares. So the total itakuwa 10. Then unapea the secretary authority, then the directors sign. Then a shareholders resolution also. Now a shareholders resolution, remember, haihitajiki kwa allotment ama transfer, because for this one it's only an ordinary. Tulisema it's an ordinary resolution. But if you are doing an increase, ingekuwa special resolution, na ingekuwa special resolution for increase. Tuachane na hiyo. Then let me show you something else. So that is the part about resolutions and everything. Sindio? Then the transfer deeds. So mnakuja mnasema Jenga Nchi Limited. This is the transfer deed. So unasema Jenga Nchi Limited. Figures ni how many shares? 5 shares. 5 ordinary shares from Rose Kumo. Then the consideration, there must be a consideration for any contract because a transfer deed is a contract in itself. So 1, 2. So the consideration is 5 multiplied by the nominal amount for each share, which is 5,000 Kenya shillings. Is the consideration yenye David atapea his sisters. Then now this is David is the recipient, who is the transferor or transferee. Sorry, the transferor is Rose Como in the first instant. Then tumesema the address is 1212 12. So hapa tunakuja tunaweka jina ya Rose. Then tunaweka jina ya David as the transferee. I'm just showing you very fast on the how to draft share transfer deeds. Then the second one itakuwa ya Cynthia Kumo. So zitakuwa transfer deeds mbili, itakuwa moja because these are two different